Ms. Hany, so.
Mr. Speaker, I would first like to declare that I'm a practicing lawyer and the chairperson of the Pro Bono SG's Community Legal Clinics Committee, as well as a member of the Law Society's Family Law Practice Committee. Mr. Speaker, I speak in support of the Family Justice Reform Bill, which aims to strengthen the family therapeutic justice. As shared during my speech last year during the debate on Women's Charter Amendment Bill, divorce is one of the most stressful events in one's life, according to the Holmes and Rahil stress scale, second only to the death of a loved one. This result doesn't come as a surprise due to the fear of navigating through many uncertainties ahead of these applicants. As a result, matters relating to divorce and subsequent related enforcement or variation applications remain as one of the most common topics inquired by applicants for preliminary legal advice at various community legal clinics ran across Singapore. During the course of my legal practice, I have represented clients in matrimonial disputes with a view to resolve matters through what is now commonly known as, by many, as the therapeutic justice approach. Many a times, clients and fellow members of the bar have asked, what exactly is therapeutic justice? In short, TJ. To me, in essence, TJ revolves around reducing acrimony in family proceedings, ensuring outcomes are deemed as practical and acceptable to parties involved without undue delays, complexity, and unnecessary escalation of cost. Over the years, there have been ongoing discussions about transitioning family law proceedings towards such less adversarial TJ approach, just as what the Honourable Presiding Judge of the Family Justice Courts, Justice Debbie Ong, had shared in the Family Justice Work Plan in 2020. Since then, the courts and the family practice community have been co-creating a renewed vision of the family justice informed by the TJ principles. However, till date, my observation is that the relevant stakeholders still have different interpretations on how a TJ approach ought to be adopted during the court proceedings. Moreover, some may still be resistant to buy into this concept. In order for this vision to come into fruition, it requires the whole ecosystem to embrace the concept, including the courts, lawyers, counsellors, and the parties involved. Together, we must work towards a common defined goal that the resolution of family disputes need not be adversarial, but should rather be focused on solutions, such as determining what outcome would be the most reasonable and practical in the best interest of the children after their parents have separated. To achieve this, both the hardware and the hardware changes are necessary. Firstly, there should be an increase in manpower and resources at the family justice courts. This will ensure that the courts are adequately equipped to handle cases in a timely and efficient manner. Take the incoming maintenance enforcement officers, the MEOs in short, for example. How many of these MEOs will the courts be expecting for the ministry to recruit in order to cope with the high volume of maintenance summons applications? Moreover, it seems to me that the workload and the job scope of MEOs are expected to be heavy, having the need to deal with not just the parties involved, but also third parties like the government agencies and financial institutions to obtain information on parties' financial situations, and thereafter, conducting conciliation sessions in advising parties and reporting these developments to the court. Secondly, there must be an emphasis on training and consistency in the management of cases across all judges, counsellors, lawyers, and even the upcoming MEOs. Such trainings should not take place separately. Currently, the family judges undergo specialist curriculum training in multidisciplinary topics, whereas the family lawyers may opt to attend the Family Therapeutic Justice Certification Program, and counsellors attend Family Counselling Certification Program respectively. Trainings for all of these relevant family justice community personnel should be carried out together, where all can partake in various role-play scenarios and have a better understanding of each other's positions by putting themselves in one another's shoes and explore how they can better work together to resolve those supposed acrimonious issues. Hopefully, these changes will gradually help to create an environment where parties involved are more inclined to consider and accept the TJ outcomes. One of the proposed changes under this Family Justice Reform Bill pertains to enhancing a judge-led approach. In this regard, I wish to seek clarifications on whether this would mean a docket system where a specific judge is assigned to a case right from the beginning when a divorce is commenced under the ordinary route to oversee the case through to its conclusion. To better promote efficiency in court proceedings, being another objective which this reform bill aims to achieve, I would urge all parties involved, including the judge, lawyers, and the parties in action, to actively work towards reaching a global settlement. In cases involving children, it should be made mandatory under the court's practice directions for parties to exchange supporting documents at the onset, which would typically only be exchanged either during the mediation or at the ancillary stage. Additionally, settlement proposals should thereafter be exchanged. If the matter still cannot be settled and has to proceed under the ordinary route, the docketed judge should promptly refer the matter for mediation, with the aim of converting parties to adopt a TJ mindset and work towards a global settlement. Additionally, MSF or the court should arrange at the earliest opportunity for the children to undergo counselling to better understand and minimize the trauma caused to the young and innocent as a result of their parents' divorce. As Mahatma Gandhi once said, an eye for an eye only ends up making the whole world blind. The dissolution of a marriage and parting ways with your spouse need not and should not be acrimonious. It is my sincere hope that this approach can be achieved in all cases, particularly those involving children once the bill has been passed and implemented. In Mandarin, please. 这次的家事司法改革法案在生效后，将让主治法官拥有更大的主导权。虽说清官难断家务事，自此我深信律政部、社会及家庭发展部以及家事司法法院会给予大众明确的肯定。这些主导权将会用在首先如何进一步的减去没必要的诉讼程序，以并减轻当事人在面对离婚手续时所面对的精神与经济压力，改善双方因离婚所造成的家庭破裂关系，以及制止在这期间任何一方对孩子有意或无意的所造成他们的心灵伤害。In conclusion, Mr. Deputy Speaker, notwithstanding the clarifications and suggestions I've raised earlier, I stand in support of this reform bill. Strengthening family therapeutic justice presents us with an opportunity to create a more compassionate and effective family law system. By embracing this approach, we can reduce the acrimony, ensure fairer outcomes, and prioritize the best interests of our children. Let us all work together towards a future where families can navigate the challenges of separation with dignity, empathy, and the welfare of our children at the forefront.